When I interview a new client, one of the first things they usually tell me is that the police did not read them their rights. Many people have the incorrect assumption that if the police didn't read them their rights, the case should be dismissed, and unfortunately this is not true. The term reading your rights is referring to Miranda warnings, which the police are required to give to a person who is in custody and who are there going to question. The key to this is in custody. The person actually has to be under arrest at the time. So let's take the situation where someone is pulled over by the police in a traffic stop, or they're talking to them on the street. The police can come up to them and ask questions such as, who are you, where are you going, what are you doing, have you had anything to drink tonight? And this is not any violation of the person's constitutional rights. However, if they've made the decision to arrest somebody and then are going to be asking them questions, they have to advise them of their rights, such as they have the right to speak to an attorney, they don't have to answer any other questions, and things like that before they begin the interrogation. If they do question a person in custody without advising them of their rights, then any statements that that person makes can be thrown out and not used against them in court. Many people don't realize that when they're talking to the police, some questions which they think could be harmless could actually be a very serious thing that could later be used against them in court. If you have been arrested and are being questioned by the police, it is a very good idea to say, I don't want to answer any questions until I speak to a lawyer first. If you do this, by law, the police are required to stop questioning at that point and not begin it again until you initiate it yourself or your lawyer does. You can always talk to a lawyer and then go back and make a statement at another time, and this is usually the best decision.